Northern Ireland Assembly, Committee Room 29. This is the Northern Ireland Assembly, Committee Room 29.
Good morning, good morning, members. Very welcome to our first meeting of the Infrastructure Committee. Today we will we'll consider the following. Will be your committee procedures, protocols and housekeeping for the new committee. We will have our statutory legislation, which will include a short we have just had a short briefing from the examiner for statutory rules, although we have an issue to deal with in respect of that. Anyone in the public gallery who is coming through the door now, we can obviously use mobile devices through a Wi-Fi connection, and all devices should be muted. Password details are available on the gallery rules for anyone wanting to connect to the Assembly's Wi-Fi network. 3G and 4G should not be used, and no recordings or photographs are to be taken during our session. I received an apology from Dolores Kelly. Are there any other apologies? Thank you. Chairperson's business. Just want members' agreement if they're content that press releases, news releases and statistical bulletins are emailed to members when they are received. They will not be included in committee meeting packs, but if you're content that they are sent out to you as they come in.
Agreed.
Okay, thank you. And are you also content that the Assembly research papers received by the committee are also published after consideration by the committee?
Agreed.
Okay, thank you. Moving then to correspondence. One piece of correspondence received from Translink, congratulating the Chair on the appointment, and myself, obviously, requesting a meeting. I, along with the Clerk and the Deputy Chair, are meeting with Translink officials on Wednesday afternoon. We've also received correspondence from the Attorney General, again congratulating the Chair and Deputy Chair, so if members are content to note that. The additional correspondence received from Translink is an invitation to an event it's in your table packs, next Wednesday the 29th of January. It's at the My Water Service Centre. Unfortunately, this is an event which obviously members would have loved to have attended, but because it clashes with our committee day, we may take opportunity then to speak to Translink about that tomorrow and maybe arrange an alternative time for members to be able to see that. I think it'd be useful for us to be able to go to the My Water Services Centre anyway, although perhaps there's a member in the committee is already aware of that, but be useful to do. So, moving then on to item 4, which are arrangements for committee meetings. The committee will normally meet weekly on a Wednesday at 10 a.m. in the Senate chamber. Once the committee has had an opportunity to plan its forward work programme, some meetings will be scheduled at venues outside of Parliament buildings, just in order to facilitate greater public access to the work of the committee. And obviously, visits will be agreed in advance and then arranged. It's standard protocol that meetings should be open to the public unless there's a particular reason for deliberations on specific agenda items to be held in closed session, for example, taking evidence perhaps on a confidential matter, receiving legal advice or agreeing a draft inquiry report. So if members are content that as a rule our meetings are held in public unless we agree to override that for a specific reason. Members agreed?
Agree with that, Chair, with the caveat that we'll try 10 o'clock for a while to see how
we may move it to 9:30. Is that right? Yeah.
May move it to 10:30, but we'll roll with the 10 o'clock for a while to see how we go.
Okay, moving then to staff contact details. Details for all the committee staff are at page 20. Just at the stage I was introduced to you are clerks. We have Alison Ross and Kathy White, who are our clerks. Kathy, would you like to introduce the other members of staff?
Our assistant clerk is Vincent Gribben, and our clerical supervisor is Johnny Lawless, and over here. And we have 2 researchers, Des McKibben and Susie Cave.
Okay. So could I just emphasise to members that in order to make sure that we do have quorum at meetings, that they do advise committee staff in advance if they plan to be absent. Appreciate that very much. Moving then to item 6, outcomes of an effective committee. There's a paper at page 20 which provides a useful summary of a wide range of effective outcomes that could potentially be achieved by a committee, and we'll spend a little bit more time on that once we start to look at our forward work programme. Moving then to item 7, that's our approach to dealing with correspondence and requests for meetings which aren't linked necessarily to our strategic priorities or statutory duties. And obviously one of the key challenges of any of the statutory committees is really managing the range and the volume of business which will come its way, and we have a very much a limited amount of time and resource available to us, so it's important that we do have an approach. There are a number of options, and perhaps, Cathy, do you want to briefly outline those?
Well, basically you have correspondence that comes from various groups, individuals, etc. And when it doesn't relate to our strategic priorities or statutory duties, we have to decide how we can deal with that. In the past, quite often, we would have agreed to go back to them, the individual, and say this is really a constituency issue, and we would issue then a letter to them with the names and addresses of the 5 local MLAs in their constituency. We also, so you may want to do that in future as well, because we'll get inundated with lots of letters, but we have to also be very mindful of the new general data protection regulations and people's rights. So in the past, sometimes we would have sent a letter on to the department asking them for comment on it. We can't do that now without consent from the individual. So there's a number of options. So if it's sort of local issues, you just can agree to do at that time when you consider it. You don't need to agree today, but you can consider when you're considering correspondence how you want to deal with it. Will we send it back to them? There's different ways as well of dealing with all the correspondence. So I think as and when it comes in, you can decide whether you want to respond to them saying there's an MLA, or say ask for their consent to forward to the department. We can send it internally to another committee in here, because that's still within this organisation. That's not breaching any data protection rights, but otherwise we have to get their permission. So I think we take it on correspondence case by case really, and decide what you want to do.
Agreed. And then in relation to
meetings, we have requests for meetings. We will have lots of requests for meetings from stakeholders, and you can decide how you want to do that. You can deal with it by asking for a written briefing, or you can deal with it by saying you'll have an informal meeting which is open to the whole committee, any member that wants to attend, or you can agree that it should be a meeting between the chair, the deputy chair and a clerk, and then report back at the next meeting to what happened. Or you can organise like stakeholder or speed dating type events where you have a lot of stakeholders involved in one particular issue, and the quickest way to do it is to have an event over like a few hours up in the Long Gallery. So again, they can be dealt with as and when they come in.
Okay, content with that approach?
Yeah, great.
Thank you. Moving then to item 8, which is the committee approach to meeting preparation and witness questioning. Again, there's a paper at page 30 in relation to that. If you're content, I'll take members in the order which they indicate in order to move the meeting on. With regards to preparation, I guess that will very much depend on individual members how they wish to proceed. There will be different approaches perhaps when we're looking at legislation, and certainly whenever we're looking at committee inquiries. So again, I suppose we can work our way through that, and we can return to that again for further discussion. Intent?
Agreed.
Item 9, protocol and conduct and courtesy at committee meetings. There's a draft committee protocol at page 34. Members content with that?
Yeah.
Okay. And then item 10 is our approach then to use of social media. The committee does have a Twitter account which has been set up and will be used at varying times depending really on what we're doing. I suppose the focus will really be on the committee work itself and alerting people to the meeting, and then to a link for our minutes. Is there anything further we need to do that in terms of reference for inquiries and so on as well? So content that we use it in that manner?
Yep.
Okay, thank you. Item 11, committee membership. If you just want to note that.
Great, yeah.
Okay. Item 12, or declaration of members' interests. All members of the Assembly are required to register relevant financial and other interests in the Register of Members' Interests, and details of registered interests are published on the Assembly website. Just in order to remind you that in addition to this requirement, Standing Order states that a member who has a financial interest in any matter or a relevant interest in any matter must declare that interest before taking part in any proceedings of the Assembly relating to that matter. In particular, there is a requirement to declare any interests which might reasonably be thought by others to influence the member's approach to the matter under consideration. Whenever we talk about proceedings, that also includes meetings of this committee. So as this is the first meeting of the committee, members should ensure that any financial or other interests which relate to the remit of the committee or which are likely to be relevant to a substantial part of its work are drawn to the attention of the committee. It should be noted that failure to register and or declare an interest may be an offence under section 43 of the Northern Ireland Act 1998. Does any member have any interests to declare? Mr. Muir.
Thank you very much, Chair. I declare that as a former employee of TransLink.
Okay, thank you.
Can I declare as Treasurer of the Carrickfergus Road Safety Committee? So if there's road safety issues that I see, I will be raising.
Thank you very much. Mr. Hilditch.
Chairman of the Carrick Road Safety Committee.
Okay, thank you very much. Okay, so I just also have to remind you that rules governing the registration and declaration of interests are contained in the Code of Conduct and guides the rules relating to the conduct of members, and that further advice and guidance is available from the Clerk of Standards in room 254 in Parliament Buildings. Okay, moving then to item 13, which are committee procedures. Just ask you to note the following guidance papers. The Guide to the Powers and Operation of Statutory Committees for Chairpersons and Members, that's at page 43. And Guide to the Role of the Chairperson, which is page 54. And Guide for Members on the Role and Functions of the Committee Office, which is at page 61. Also draw your attention to guidance on privilege and matters which are sub judice. Under section 50 of the Northern Ireland Act 1998, for the purposes of the law of defamation, absolute privilege applies equally to the making of a statement in proceedings of the Assembly and the publication of a statement under the Assembly's authority. This privilege also extends to meetings of the committee. Members should note, however, that privilege does not extend to press conferences or statements made to the press. Committee members should be aware of the potential problems associated with discussing a matter that is sub judice. That is a matter which is being or is about to be considered by a court. Sub judice rule required by section 41 and Schedule 6 of the Northern Ireland Act 1998 is contained in Standing Order 73. It provides that any matters in respect of which legal proceedings are active should not be referred to in committee proceedings except to the extent permitted by the committee chairperson. In such cases, the matter awaiting adjudication should not be prejudiced by statement in a public session of a committee meeting. The rules relating to this are summarised in the Guide to the Powers and Operation of Statutory Committees for Chairpersons and Members. Members have obviously been provided with this. So, okay. Moving then to guidance on timescales for interaction between committees and departments. Just ask you to note the guidance paper at page 63, which sets out those timescales for the provision of information and evidence between the departments and committees. And this was agreed by the Executive and the Assembly Chairperson's Liaison Committee. So moving then on to subordinate legislation, item 15, which is the delegation of technical scrutiny to the Examiner of Statutory Rules, and we have heard from Angela Kelly. So I would just like the committee to agree the following motion: that the Committee for Infrastructure, under Standing Order 43, resolves to delegate to the Examiner of Statutory Rules any of its functions in relation to the technical scrutiny of the instrument. The committee further resolves that in carrying out this function, the examiner shall be authorised to report his technical findings on each statutory rule to the Assembly and to the relevant department, as well as to the committee itself, and to publish his report. Okay, content?
Agreed.
Thank you. So we're moving then on to our main business of today, and just to advise you that we have 275 statutory rules laid by the department that need to be considered by this committee. So obviously today and tomorrow we've set aside time in order to consider those SRs that are subject to negative resolution, and that's 81 in total. This time's insufficient. We may consider looking at this again then into next week's meeting. It really just depends on how we move forward on this. Mr. Beggs.
Can I highlight a degree of concern that we were given two 2-inch ring binders of documentations for today's meeting. I think I picked mine up probably about 3 o'clock yesterday afternoon. I had similar issues to deal with yesterday. I don't know about everybody else, but I certainly had a very late night last night, and some of the issues that might be useful if we had more time to study, but I'll raise them as it comes along. But it really, the amount of detail that we're given, we've been given a very short period of time to study.
And I appreciate that, and obviously I'm in a similar position, and again it was a late night, but I think there were constraints obviously from the committee office in relation to getting things printed and so on as well. As you're aware, we don't have.
We were only recalled last week.
And again, we were only recalled last week, so everything has been done in great haste. So I suppose there's a caveat against all of that. So okay. We have our statutory rules then are at pages 87 to 1143. The SRs have been grouped by subject area to assist members. There are 41 abandonment orders where the department is abandoning a piece of land rather than maintain and be responsible for its upkeep. Committee staff have reviewed all 41, and all documentation is available, including the explanatory memorandum outlining the rationale and the consultation stage. For each of the 41, the PSNI were informed of the abandonment and had no issues. Each was advertised in the local paper for 2 weeks, and there was only one where there was an objection raised. There were also no regulatory, financial or Section 24 implications. There are 9 negative resolutions that relate to roads but are not abandonment orders, 18 relate to vehicle regulations, and 13 are miscellaneous. Any particular issues will be highlighted as the committee considers. Yes, Mr. Beggs.
They've been advertised in local newspapers. I'm just seeking clarification. The circulation of local newspapers is considerably down from where it used to be. Do the immediately adjacent property owners get individual notification?
No idea. I need to ask the
We need
officials.
to ask the officials whenever they come,
Okay.
and certainly once we go through each of the SRs, I'll give a summary, and if you do require any additional information or clarification, we have officials on hand to deal with each of the issues. So feel free. I will ask at each juncture if members wish for further information, and we can request that. So. Okay, so are we content then to start to move forward? I think by the end of this you will be tired of listening to my voice, but and I hope that it holds up. But so we move to the first one, which is SR 2017-95, the Hannistown Hill Belfast Abandonment Order, Northern Ireland 2017. It's at page 87. The purpose of the rule is to abandon an area of superseded road at Hannistown Hill in Belfast. On the coming into operation of the rule, the area of road in question shall cease to be maintainable by the department, and the public right-of-way over it shall be extinguished. Are members content with this rule? You require information? Content. The Committee for Infrastructure has considered SR 2017-95, the Hannistown Hill Belfast Abandonment Order, Northern Ireland 2017, and subject to the Examiner of Statutory Rules report, has no objection to the rule. Agreed?
Great.
Item 17.
Chair, can I just ask a question? Given that if these roads are already being abandoned and we're doing this retrospectively, do we know that?
Well, I know of one in my area which has. I'm not sure about the others, but
What routes are we looking for?
would you like an official to come
Yeah.
to speak to us? We have from the first one, She's
Martin Smith, Victor Clegg, Basil Hazard, Dr. Colin Pentland. They need to identify who they are for new
Okay.
appeals. And there's this Martin Smith. Martin Smith and Victor
Martin.
Clegg.
Very welcome to committee. But just a brief question,
Yes,
Mr. McCartney.
I mean, are we approving these retrospectively? Have you actioned these?
Basically, yes, these have already taken effect in all cases.
Yeah.
All the statutory rules that are made here, yeah.
And in effect, say this morning we decided not to do this, there's no real consequence?
No, and most of them, as I say, all the statutory rule, when the rule is made, the law has ordinarily taken effect. There's a couple on here where maybe, I mean, I know of one in particular that affects me, it doesn't take effect until Friday.
Okay.
But usually, yes, there will have been a date when they've taken effect from, especially the older one.
You can tend to stay at the table in case there are any issues, just as we move through, and if there's someone else, we can swap accordingly, if that's okay, if you contend to do that. Okay, so I'm content with to move on then to item 17, page 95, and this, the purpose of this rule is to abandon 190 square metres of road consisting of 2 areas of footpath at Ban Drive in Londonderry. On the coming into operation of the abandonment, the areas of road in question shall cease to be maintainable by the department, and the public right-of-way over them shall be extinguished. Are members content with this rule? Mr. Beggs?
Looking at the drawing, I have no issue with the northerly footpath where I can see an alternative footpath is provided. But in the southerly section, it would appear we're abandoning a footpath, and it's mentioned that there's an environmental improvement scheme. But I'm seeking reassurance that that encompasses a footpath for the public, or are we leaving a section of road without a footpath outside a community centre?
We have Mr. Dutt, could you come forward?
You have to
You have to come forward, please.
What's his name?
Mr. Dutt. Is it Rory?
No, there's no section that's been abandoned. There'll be a footpath going the whole way round. There's part of it does go to the opposite side of the road on Ban Drive, but there is a footpath linking from the community centre the whole way round.
I'm just seeking clarification. So you're saying that a member of the public that would be walking up alongside the front of the community centre would have to cross the other side of the road, walk a little bit and then cross back?
Yes.
Why do we abandon this stretch of property where there's a right of way instead of ensuring there's a footpath?
The reason why it was abandoned was because Derry City Council had an environmental improvements scheme. They were putting like a play park on that piece of ground, and they wanted the footpath taken away.
We're going to have a play park, which is very good, but the children in the play park might actually be endangered because of the missing footpath.
Well, they can actually enter it from there in front of at the community centre.
I would like to express my concern. I would like to have a detailed drawing of this, but it's very difficult to ascertain from this sketch. But we are removing a section of footpath in front of a community centre and forcing users to cross the road twice, potentially.
And has this already been done?
This has been done. This came into operation in 2018.
And have there been any objections?
None whatsoever. All frontagers were spoken to, the local community. I personally was at the community centre, spoke with all the representatives there. They all welcomed the decision. And there wasn't a single objection.
Okay.
I've made my point. I propose that we get a detailed drawing of what has been proposed and investigate why a public footpath is being abandoned and forcing people who are using public facilities to cross the road twice who might be walking in front of it.
Can we get any additional information in relation to that in
Well,
order
I
to
could
assist
ask,
Mr.
I could ask for a map of the area. I wouldn't be able to get that this morning now.
Would it be possible, we were obviously meeting tomorrow, would it be possible to get that information for it to be
Quite possibly, yes.
tomorrow?
Yes.
Thank you. We'll hold that,
For a decision.
defer that decision until tomorrow. Okay, moving then on to Page 105, which is SR 2017-97, it's the Orchard Road Industrial Estate in Strabane. The purpose of this rule is to abandon an area of the northern turning head of the road in the Orchard Road Industrial Estate. The area of road will be abandoned on the completion of works to provide an alternative turning head. On the completion of those works, the area of road in question shall cease to be maintainable by the department, and the public right-of-way over it shall be extinguished. Street lights equipment will be removed, but all other existing cables, wires, mains, pipes, or other apparatus placed along, across, over or under the abandoned area of road shall be retained, and all existing rights as to the use or maintenance of such cables, wires, mains, pipes, or other apparatus shall be preserved. Are members content with this rule?
Just a question for the officials. You see, under application, we talk about existing rights for cables. Is that their normality in every situation where the land is sold for footpath or sold for a turning circle? Is that the normality that the existing rights maintained?
Ordinarily, for utility companies who already have equipment and all, they essentially need that guarantee that they're allowed to access the equipment or access that space after the abandonment.
So if an individual purchases that piece of land, are they made aware of that through the solicitor?
They should be made aware of that. Occasionally, yes, there will be requests by the utilities for easements or way leaves or whatever if they have equipment under land. So that would be appended to any.
And that obviously relates to, presume, 80% of these, I presume, or whatever. Thank you.
Members content with the rule? Agreed. Okay. The Committee for Infrastructure has considered SR 2017-97, the Orchard Road Industrial Estate Strabane Abandonment Order, Northern Ireland 2017, and subject to the Examiner's Statutory Rules report, has no objection to the rule. Next one, item 19, SR 2017-98, and the purpose of this is to abandon 1,824 square metres of superseded road on the A27 Points Pass, Scarva, at what is locally known as Jackson's Corner. On coming into operation of the abandonment, the area of road in question shall cease to be maintainable by the department, and public right-of-way over it shall be extinguished. Are members content with this rule?
Agreed.
Okay, thank you. That the Committee for Infrastructure has considered SR 2017-98, the A27 Points Pass Road, Scarva Abandonment Order, Northern Ireland 2017, and subject to the Examiner's Statutory Rules report, has no objection to the rule. Item 20, SR 2017-124. The purpose of this rule is to abandon an area of footpath adjacent to the Arago Inn, Omer Road, Belfast, and coming into operation of the abandonment, the area of road in question shall cease to be maintainable by the department, and the public right-of-way over it shall be extinguished. Mr. Beggs.
I see from the background information that the request has come in from the licensee, the owners of Arago Inn on the road, and he wishes to use it for a seating area for licence purposes. My question is, and I say there's no objections, but my question is, essentially that will enhance the business. Does this land transfer following assessment from LPS and the value of it be ascertained, given the fact that it could enhance the business? We're all very short of capital expenditure, so I'm seeking reassurance if someone is benefiting from transfer of land, that the public also benefit.
Basically, yes, once the abandonment process is complete for that area. The proprietor already had a licence under the street licensing to have that outdoor area. He has now applied to the department to purchase that land, basically.
Okay.
But first we need to do the abandonment order before we can then dispose of the land to him, and yes, it will be valued by LPS.
Recognising the benefit of the business.
Yeah.
Thank you.
Okay, content? Okay. The Committee for Infrastructure has considered SR 2017-124, the Omer Road Belfast Footway Abandonment Order, Northern Ireland 2017, and subject to the Examiner's Statutory Rules report, has no objection to the rule. Item 21, SR 2017-161, which is page 131. The purpose of this rule is to abandon an area of road at the southwest side of Glenwood Green in Murray. The coming into operation of the rule, the area of road in question shall cease to be maintainable by the department, and the public right-of-way over it shall be extinguished. The department is of the opinion that the road is no longer necessary for road traffic. Members content? Mr Beggs?
I don't know about other members, but I have a very poor map and I have a lack of clarity of exactly where the boundary is. My question is, does this include, it appears to include part of the Glenwood Court Road, which would be accessing a considerable number of houses. So I'm seeking reassurance that it doesn't include that bit of access to what is a number of properties in the area.
Essentially, the thinking behind this scheme was there was an area of land that was to be redeveloped for social housing. So whenever the scheme was constructed on the ground, no, that entry that you're talking about has been maintained. It has actually slightly moved to allow space for cars coming in to access the new properties.
Right.
So the existing properties are still serviced fully, yeah.
But my specific question is, it appears in my drawing that the edge of the map, relevant map, includes part of Glenwood Court, which is only impacting on the residents of it. So my question is, does it include part of Glenwood Court? Because the map I have is not clear.
I don't have that map at the minute, but let's see. No, the area delineated in red is the only area to be abandoned.
We don't have it. We only have it black and
Only a
white.
black and white copy.
You only have black and white, do you?
Can I briefly see it?
Yes, of course.
Okay, that's fine. Fine, content.
Content? Okay, thank you.
Chair, can I just add, in this subject, I see under the explanatory memorandum where it says financial implications none. In the last one, there is a financial implication because it's going to be purchased, but what does financial implication mean there? Is that just to use it as it goes through?
If there's any cost in any way, any cost to the department, or if the department is to sell property or anything like that, so there are no implications in this matter.
Yeah, so when you say none, it doesn't mean then it's subject, it can be purchased by somebody else? It doesn't cover that part of it?
I think if I remember right in this case, the land was already owned by the Northern Ireland Housing Executive.
Yeah.
So
I'm just talking in general, I'm not talking about, I'm just talking in general. When you say implication, financial implications none, it doesn't exclude that there's a fact that in the previous one, a proprietor is going to buy the land.
yes, because in the previous one, CFI owned the land.
Yeah.
In this case, CFI didn't own the land. We had only adopted the land as such, so there's no implication directly on the department.
And can I just ask what the plans are then for this land?
Sorry?
What are the plans for this land once it's now been abandoned?
There's actually new houses on the land.
There are new houses.
Basically, there's social housing has been.
They're already built on the land.
It's already built there.
All right. Okay.
No question. There's no question about that. There's no member going to comment on that there. No members. Move on. Support that in there, Chair. Support that more. Agreed.
I think Roy and I were going to bed last night.
So, that the Committee for Infrastructure has considered SR 2017-161, the Glenwood Green Dunmurray Abandonment Order, Northern Ireland 2017, and subject to the Examiner's Statutory Rules report, has no objection to the room, which is just as well.
Great.
Agreed.
Moving then to item 22, which is SR 2017-170, and that's at page 139. And the purpose of the rule is to abandon an area of road comprising road embankment adjacent to Market Hill Free Presbyterian Church on the B3 Tandragee Road, Market Hill. And the coming into operation of the abandonment, the area of road in question shall cease to be maintainable by the department, and the public right-of-way over it shall be extinguished. Are members content with the rule?
Chair, just on one question, I don't want to call it hearing up to the floor. It's okay, but it's a general question I see, because there's a couple that come up in my own area. In terms of, there's been no comment from council on that of them. What's the role of the council? The council are notified there, and I'm not saying whether they agree or disagree with it. Obviously, they haven't commented here, but a generality, you know, because I mean, Roy's been asking questions. He said all night to 3 o'clock in the morning. The issue for me is, I mean, as a councillor, if there was issues brought up, you know, or somebody in council would have flagged up, if there had been an issue, but it's just a general question.
Ordinarily, yes, for any particular abandonment that comes up, yes, letters will be sent out to all councils
Right.
that are affected. It's usually the Chief Executive's Office, Development Control, or whatever they go under.
And if there's any problems there, it
there's
would
any
be
problems, then
flagged,
they'll
flagged
come
up
back
as
to
well.
us,
Yeah. No, appreciate it.
Okay.
Yeah, thank you,
So
Chair.
members content with this rule?
Great.
The Committee for Infrastructure has considered SR 2017-170, the B3 Tandragee Road, Market Hill abandonment order, Northern Ireland 2017, and subject to the examiner of statutory rules report, has no objection to the rule.
Great.
Next one, item 23, SR 2017-192, statutory rules at page 147. The purpose of this rule is to abandon an area of road comprising carriageway and footway, part of a former roundabout at the Manor Blacks Road, Belfast. On the coming into operation of the abandonment, the area of road in question shall cease to be maintainable by the department and the public right-of-way over it shall be extinguished. Are members content with this rule?
Great.
That the Committee for Infrastructure has considered SR 2017-192, the Manor Blacks Road, Belfast Abandonment Order, Northern Ireland 2017, and is subject to the examiner's statutory rules report, has no objection to the rule.
Great.
Next item 24 is SR 2017-193, statutory rules at page 155. The purpose of the rule is to abandon an area of road comprising footway at Greymore Road, Taza, PD, adjacent to its junction with the entrance to St Mary's. I probably pronounced that wrong, have I?
No, you were going well there, Greenmore Task. That's okay. You're close enough.
Okay. To its junction with the entrance to St Mary's Primary School.
Yeah.
The area of road in question will be abandoned after completion of such works the department considers necessary. The area of road in question shall then cease to be maintainable by the department and the public right-of-way over it shall be extinguished. Are members content with this rule?
Yeah.
Thank you. Oh,
Just one question.
Buchanan.
Presume the footway has been constructed?
Yeah. It is, yeah.
Okay, thank you. That the Committee for Infrastructure has considered SR 2017-193, the Greymore Road, Taza, Keady Abandonment Order, Northern Ireland 2017, and subject to the Examiner of Statutory Rules report, has no objection to the rule.
Agreed.
Item 25, SR 2017-195, statutory rules at page 162. That the purpose of the rule is to abandon an area of 350 square metres of road comprising carriageway and footway adjacent to Meadow Lane, Portadown. The area of road in question will be abandoned after completion of such works as the department considers necessary. The area of road in question shall then cease to be maintainable by the department and the public right-of-way over it shall be extinguished. Are members content with this rule?
Great.
Thank you. The Committee for Infrastructure has considered SR 2017-195, the Meadow Lane, Portadown, Belfast Abandonment Order, Northern Ireland 2017, and subject to the Examiner of Statutory Rules report, has no objection to the rule. Okay.
Great.
Item 26, SR 2017-237, it's at page 170 papers, that the purpose of the rule is to abandon 694.5 square metres of road comprising road embankment adjacent to Derrycarn Road in Portadown. On the coming into operation of the abandonment, the area of road in question shall cease to be maintainable by the department and the public right-of-way over it shall be extinguished. Members, any queries? Are you content? Content with this rule, okay. So the Committee for Infrastructure has considered SR 2017-237, C161, Derrycarn Road, Portadown Abandonment Order, Northern Ireland 2017, and subject to the Examiner of Statutory Rules report, has no objection to the rule. Item 27, it's SR 2017-239, find that at page 178 of your pack. The purpose of this rule is to abandon a length of superseded road, the former C158 Ballynacore Road, Portadown, in Ballynacore Townland in County Armagh. On the coming into the operation of the abandonment of this length of road in question, the department will cease to maintain it and the public right-of-way over it shall be extinguished. Are members content with this rule? If any questions, Mr.
I
Buchanan.
have a question. How is access provided to number 22 if it still exists? presume there is access still for property 22, or maybe it doesn't exist?
Sorry, you need to come forward, so apologies.
As an adjacent landowner,
You need to sit down at the mic, I'm sorry.
all the adjacent landowners are consulted, so if any impact on anybody when the road's abandoned would have been discussed with them. I would assume that number 22 no longer exists, or else the adjacent landowner actually owns the property.
So whoever owns 22, or at least a piece of ground, would have been consulted?
Yeah.
Okay.
Thank you.
And that the Committee for Infrastructure has considered SR 2017-239, the former C158 Ballynacore Road, Portadown Abandonment Order, Northern Ireland 2017, and subject to the examiner's statutory rules, report has no objection to the road.
Great.
Thank you. Item 28, which is SR 2018-13, statutory rule found at page 186 of your packs. The purpose of this rule is to abandon an area of 581 square metres of former road comprising 320 square metres of former carriageway and an area of 261 square metres of former road verge in front of number 111 Woodtown Road, Ballymena. On the coming into operation of the abandonment, the area of road in question shall cease to be maintainable by the Department and the public right-of-way over it shall be extinguished. Do members have any queries or questions?
Yeah.
Mr Buchanan.
Yeah, sorry, the access, I presume, is from the other direction on Woodtown Road?
Here's somebody else coming in there.
Oh,
What's the name?
Yeah, Cathal, sorry. The access then to, for example, 106 Woodtown Road, I presume it's from the other direction now. Is that blocked off and closed off?
Sorry, if you could apologise, could you repeat the question again?
So access to that, for example, 106 Woodtown is cut from the other direction, obviously, now?
Oh, yes, the Woodtown Road, that's the existing road. The U 2029 is existing road. The alignment actually just took place towards the junction, towards the Cullibackie Road.
Yeah, the B62, yeah.
Yeah, so no, the existing access for the 106 is out onto Woodtown Road.
And is that currently closed as we speak, I presume?
No, those are existing accesses.
Yeah, but it's blocked now, that access. What year was that?
I think the map we have not showing an alternative route onto the B62 Cullibackie Road. Just appears at the end of the road, I think that's it.
The actual realignment, if it's that map is the one you're looking at, the actual alignment only really took place from, see where the wording area to be abandoned is, from that point onto the Cullibackie Road.
So can I still travel from 106 Woodtown Road directly to Cullibackie Road today? In a car or vehicle?
Yeah, well, you would have to go out onto the Woodtown Road and then come down to the junction.
Yeah, but it just shows you that it's blocked off. But there is vehicle access today.
There is a new link.
Fair enough.
Yeah, that's what's missing in our map.
That's all. Fair enough.
It's really for network development, safety improvement. When you crossed over the Woodtown Road at Cullibackie, was quite a short stagger. Just to increase the stagger for safety.
It just shows that the road is technically blocked around. As long as you have access both ways, that's fine.
Oh, no.
okay, thank you. So content?
Yeah.
The Committee for Infrastructure has considered SR 2018-13, the Woodtown Road Ballymena Abandonment Order, Northern Ireland 2018, and subject to the examiner's statutory rules report, has no objection to the rule.
Great.
Going then to item 29, which is SR 2018-14, and that's 194 of your pack. The purpose of this rule is to abandon an area of superseded road to the front of 254 Tandragee Road, Portadown. On the coming into operation of the abandonment, the area of road in question shall cease to be maintainable by the Department and the public right-of-way over it shall be extinguished. Members have any queries in relation to this one?
Can I just ask a general question? Would the landowner purchase the land then? Or is it
He, as far as I'm aware, he actually owned the bedding soil, so it reverted to him.
Well, just in a general principle, if someone applies for an abandonment order, then they purchase the...
Yeah, it goes through the statutory procedures for the disposal of surplus land, yeah.
Okay.
And it would go to the district valuer for market value.
Okay, thank you.
Okay, happy? The Committee for Infrastructure has considered SR 2018-14, the B78 Tandragee Road, Portadown Abandonment Order, Northern Ireland 2018, and subject to the Examiner of Statutory Rules report, has no objection to the rule.
Agreed.
Item 30, which is SR 2018-20, and that can be found at 202 of your packs. And the purpose of the rule is to abandon an area of superseded road at the U7882 Old Road, Points Pass, at its junction with the A27 Church Road. The area of road in question will be abandoned as the department is of the opinion that the road is no longer necessary. In the coming into the operation of the rule, the area of road in question shall cease to be maintainable by the department and the public right-of-way over it shall be extinguished. Are members content with this rule, or do you have any queries? Content?
Content, yep.
Okay. The Committee for Infrastructure has considered SR 2018-20, the U7882 Old Road Points Pass Abandonment Order, Northern Ireland 2018, and subject to the Examiner of Statutory Rules report, has no objection to the rule. Item 31, which is SR 2018-22, the new line, Carrickfergus Abandonment Order, Northern Ireland 2018. Find that at page 210. And the purpose of the rule is to abandon a length of road at New Line, Upper Woodburn in Carrickfergus. And then again, on the coming in of this, there'll be the abandonment, the length of road in question shall cease to be maintainable by the department and the public right-of-way over it shall be extinguished. Do members have any concerns in relation to this or any queries? Two locals here. Sorry?
Welcome it. It'd be nice
Welcome
to be
it.
over there and stumping us that one.
Okay, content. So that the Committee for Infrastructure has considered SR 2018-22, the new line Carrickfergus Abandonment Order to Northern Ireland 2018, and subject to the Examiner Statutory Rules report, has no objection to the rule. Okay,
Great.
Thank you. Item 32, SR 2018-27. Find that at page 218 of your packs. The purpose of the rule is to abandon an area of road in Ainsborough Industrial Estate, Largan, consisting of carriageway and footpath in front of Units 20 and 21 Ansborough Industrial Estate, Ansborough Road, Largan. And then the coming in to operation of the abandonment, the area of road in question shall cease to be maintainable by the department and the public right-of-way over it shall be extinguished. Are members content, or do you have any queries?
Content.
Content. Committee for Infrastructure has considered SR 2018-27, the Ansborough Industrial Estate, Ansborough Road, Largan Abandonment Order, Northern Ireland 2018, and subject to the Examiner of Statutory Rules report, has no objection to the rule.
Great.
Item 33, SR 2018-72, Statutory Rules at page 226 of your packs. And the purpose of this rule is to abandon an area of road comprising 263 square metres of grass verge adjacent to the northern footway of Crescent Link Londonderry, extending from a point 9 metres east of Lisnagelvin Road for a distance of 120 metres in a northeasterly direction. On the coming into operation of the rule, the area of road in question shall cease to be maintainable by the department and the public right-of-way over it shall be extinguished. The department is of the opinion that the area of road is not necessary for road traffic. Members content?
Content.
Any further queries in relation to that? No? Okay. That the Committee for Infrastructure has considered SR 2018-72, the Crescent Link Londonderry Abandonment Order, Northern Ireland 2018, and subject to the Examiner of Statutory Rules report, has no objection to the rule. Getting into item 34, SR 2018-73. Statutory rule information is page 234 in your pack. The purpose of this rule is to abandon an area of road comprising grass verge at Gardener's Cross Road at Maguire's Bridge. Again, on the coming into operation of the abandonment, the area of road in question shall cease to be maintainable by the department and the public right-of-way over it shall be extinguished. Are members content with this rule, or have you any queries?
Just a question.
Mr Buchanan?
Is there any issue with the road safety in that corner there? Usually, obviously, you've normally a fence set back for going around a corner.
No, I've been assured that there's no issue of road safety. It went through the traffic section, our own local traffic section, and they give that the go-ahead as well.
So that Gardner Crossroad, is that like a sweeping corner, or is that a junction there? It's hard to determine.
Yeah, it's a bit of a sweeping corner there on Gardiner's Cross.
Okay. So that fence has obviously moved right out again the road age now, or?
Yeah, well, yes.
You've reduced your verge by whatever meterage that is.
Yes.
Okay.
Thank you, Mr McCartney.
Thank you. In the explanatory notice says that the department and the developer agreed to swap the ownership of land. What's that process entail?
Well, what'll happen there will be a piece of ground has been abandoned. Okay, there'll be a submission made to the Land and Property Services, and what they'll actually do, they'll put a value on that piece of ground, and there'll be a value on the other piece of ground. Okay, so they'll essentially give us, swap it over just really. Okay. But it'll be at market value.
Okay, thank you.
Okay, content?
Yeah.
So the Committee for Infrastructure has considered SR 2018-73, the Gardiner's Cross Road, Maguire's Bridge Abandonment Order, Northern Ireland 2018, and subject to the Examiner's Statutory Rules Report, has no objection to the rule. Moving then to item 35, SR 2018-74, you'll find the statutory rule at page 242 of your packs. The purpose of the rule is to abandon an area of road comprising former footway at Linsfort Road Drive in Londonderry. The department is satisfied that the area of road to be abandoned is not necessary, and on the coming into operation of the abandonment, the area of road in question shall cease to be maintainable by the department, and the public right-of-way over it shall be extinguished. Members content, or any queries? Content. So the Committee for Infrastructure has considered SR 2018-74, the Linsfort Drive, Londonderry Abandonment Order, Northern Ireland 2018, and subject to the Examiner's Statutory Rules Report, has no objection to the rule. Okay. Item 36, which is SR 2018-75, and you can find this page 250 of your pack. The purpose of the rule is to abandon 364 square metres of road beginning at the junction of the U1371 unnamed road with Long Lane Portadown and extending for a distance of 50.83 metres in a northwesterly direction after the completion of such works as the department considers necessary for the provision of alternative facilities for road traffic. And on the coming into operation of the abandonment, the area of road in question shall cease to be maintainable by the department, and the public right-of-way over it shall be extinguished. Are members content? Have you got a query, Mr McCartney?
It is the technical thing. It says here the developer has been unable to identify the owner of the land. What's the process then? It says that the developer has been unable to identify the owner.
Well, then he accepts the risk then of whether or not to purchase, that somebody could come along at a later date, so he has to accept that risk. If the land's unregistered and we can't determine the owner, then obviously the developer would have to accept that risk.
Okay.
And he's told about that.
Excellent, thank you.
Okay, content? The Committee for Infrastructure has considered SR 2018-75, the U1371 unnamed road off Long Lane, Portadown Abandonment Order, Northern Ireland 2018, and subject to the Examiner's Statutory Rules Report, has no objection to the rule. Item 37, which is SR 2018-76. This can be found at page 258 of your pack. And the purpose of the rule is to abandon 370 square metres of road on the north side of Limavady Road, Garva, extending from a point 186 metres west of its junction with Main Street for a distance of 46 metres in a westerly direction. After the completion of such works, the department considers necessary for the provision of alternative facilities for road traffic. A new 2-metre wide pathway along Limavady Road will be created to provide alternative facilities. On the coming into operation of the abandonment, the area of road in question shall cease to be maintainable by the department, and the public right-of-way over it shall be extinguished. Mr Beggs.
Firstly, going to say that the map provided to us is a 1 in 2,500 scale, so it's quite minute of what we're looking at. But from what I can see, there is a laneway adjacent to this property which requires sight lines over this, and my question is, how are we ensuring road traffic safety? How will that sight line be maintained? Because it does appear to serve a number of properties. I'm not sure, but that's the impression I have. They're certainly heading up the laneway. So how are sight lines going to be maintained? It would appear from the alternative facilities drawing which is provided that the land's to be incorporated into perhaps rear or front gardens. So the question is, how are sight lines going to be maintained to protect public safety of road users?
That was the old police station, so it was. It's been redeveloped, so it has. There's a new footway along and a new private streets determination associated with the site. Your questions related to the laneway. The sight lines and the non-critical side are over that land, and they would have been protected through the disposal process.
How do you protect them through the disposal process?
Well, you identify what display was, what display requirement was, and you ensure that across the determined area that the sight line is protected.
Okay.
Okay, thank you. So the Committee for Infrastructure has considered...
Could I just, on the other side, the other side, the critical side, the land is outside.
I understand.
Okay, content. The Committee for Infrastructure has considered SR 2018-76, the Limmer Valley Road Guardrail Abandonment Order, Northern Ireland 2018, and subject to the Examiner of Statutory Rules report, has no objection to the rule. Item 38, which is SR 2018-117, and this at page 266 of your packs. And the purpose of this rule is to abandon an area of 155 square metres of road at Hillsborough Road, Moneyray, and to stop up Hillsborough Road at the Moneyray, Hillsborough Road crossroads at Moneyray. I'm very familiar with the site and obviously I've welcomed it. Are members any comments in relation to it? No? Okay, so
Opinion?
the Committee for Infrastructure has considered SR 2018-117, the Hillsborough Road Moneyray Abandonment, the Stopping Up Order, Northern Ireland 2018, and subject to the Examiner of Statutory Rules report, has no objection to the rule.
Great.
Item 39, which is SR 2018-118, and find that at page 275 of your packs. And the purpose of the rule is to abandon an area of road comprising former carriageway fronting at number 3 Station Road, Moira. On the coming into operation of the abandonment, the area of road in question shall cease to be maintainable by the Department, and the public right-of-way over it shall be extinguished. Are members content with this rule?
Great.
Mr McCartney.
Just a technical adverse possession claim.
This abandonment came about essentially the road, whenever the M1 was built, the Moira Road was actually realigned. There was a new bridge put over the motorway. This is the old road. Now, up until recently, it had just lain there dormant. The property owner has been using that here as a farm, and he's up and down that road all the time. Because it has been unused by the public for 30 years or whatever, he's claiming it as his own.
That's adverse possession.
Okay. That's an adverse possession, yeah.
Okay, thank you. So, members content that the Committee for Infrastructure is considered as... Oh, sorry, Mr.
Sorry,
Buchanan.
just one question. So access to those houses is by what means?
And there's an entry off the Moira Road into those houses anyway. Most of what you'll see on the map are actually outbuildings.
Okay, so fair enough. And they're not dwellings as such?
No.
Okay, content?
Yeah.
So the Committee for Infrastructure has considered SR 2018-118, the Station Road Moira Abandonment Order, Northern Ireland 2018, and subject to the Examiner of Statutory Rules report, has no objection to the rule. Content?
Agreed.
Item 40 is SR 2018-119, and you find that at page 283 of your packs. The purpose of this rule is to abandon an area of the road embankment south of the M1 motorway westbound off slip at junction 14 in the townland of Tamnamore in Dungannon. The coming into operation of the abandonment, the area of road in question will cease to be maintainable by the Department, and public right-of-way over shall be extinguished. Members, any queries? Or we content? Mr. Buchanan?
Just a question on that. The gentleman or company that wants to purchase that, I presume, what's the planning regulation to prevent anybody moving towards the motorway, as in building on that land?
Well, indeed, that's something that will actually pass through our development control. You know, if when a planning application is actually made, development control would make comment on that.
Based on the proximity to the road?
Yes.
Okay.
We can move.
Fair enough. Thank you.
Okay, thank you. The Committee for Infrastructure has considered SR 2018-119, the M1 motorway westbound offset at Tamnamore roundabout, Dungannon abandonment order, Northern Ireland 2018, and subject to the Examiner of Statutory Rules report, has no objection to the rule. Item 41, which is SR 2018-120, Statutory Rule found at page 291. And the purpose of this rule is to abandon an area of the road embankment adjacent to number 91, Derrycarn Road, Portadown. On the coming into operation of the abandonment, the area of road in question shall cease to be maintainable by the department, and the public right of way over it shall be extinguished. Do members have any queries? Questions? No. All content. Thank you. The Committee for Infrastructure has considered SR 2018-120, the C161, Derrycarn Road, Portadown abandonment order, Northern Ireland 2018, and subject to the Examiner of Statutory Rules report, has no objection to the rule.
Great.
Item 42, which is SR 2018-159, you'll find that at page 299 of your packs. And the purpose of the rule is to abandon two areas of road totaling 249 square metres at Faird Meadow, Antrim, consisting of 31 square metres of footway and grass verge on the north east side and 218 square metres of carriageway, footway and grass verge on the south east side. And again, on the coming into operation of the rule, the areas of land and road in question shall cease to be maintainable by the department, and the public right of way over it, them shall be extinguished. Do members have any queries? No? No. All content? Thank you. Great. That the Committee for Infrastructure has considered SR 2018-159 for Meadow Antrim abandonment order, Northern Ireland 2018, and subject to the Examiner of Statutory Rules report, is no objection to the rule. Item 43, SR 2018-160, and you find that at page 307 of your packs. And the purpose of this rule is to abandon an area of road verge adjacent to number 38 Anna-Gila Road, Auker, Dungannon. On the coming into operation of the rule, the area of road verge in question shall cease to be maintainable by the department, and the public right of way over it shall be extinguished. Do members have any queries on this one? Content? Okay, thank you. So the Committee for Infrastructure considered SR 2018-160, the Anna-Gila Road, Auker, Dungannon abandonment order, Northern Ireland 2018, subject to the Examiner of Statutory Rules report, is no objection to the rule. Item 44, which is SR 2019-94, find this at page 315 of your packs. The purpose of this rule is to abandon 198.6 metres of road comprising 3 lengths of footpath at the former Craigavon Motorsports Centre adjacent to Southern Lake Craigavon after the completion of such works as the Department considers necessary for the provision of alternative facilities for road traffic. On completion of such works as the Department considers necessary for the provision of alternative facilities and the coming into operation of the abandonment, the 3 lengths of road in question shall cease to be maintainable by the Department, and the public right of way over them shall be extinguished. Members have any concerns or queries? All content? The Committee for Infrastructure has considered SR 2019-94, the footpath Centre Walk, Cherry Path and Lakeside Walk, Craigavon abandonment order, Northern Ireland 2019, and subject to the Examiner of Statutory Rules report, is no objection to the rule. Item 45, which is SR 2019-96, and you find that at page 323 of your packs. And the purpose of this rule is to abandon an area of 102 square metres of road adjacent to the side and rear of the Walkway Community Centre, Pinvoy Street in Belfast. The area of road in question will be abandoned as the Department is of the opinion that the road is not necessary. On the coming into operation of the road, again, the area of road in question shall cease to be maintainable by the Department, and the public right of way over it shall be extinguished. Members have any queries with regard to this item? No? Okay, thank you. The Committee for Infrastructure has considered SR 2019-96, the Finvoy Street Belfast Abandonment Order, Northern Ireland 2019, and subject to the Examiner's Statutory Rules Report, has no objection to the rule. Content.
Agreed.
SR 2019-97, and you find that at page 331 of your packs. And the purpose of the rule is to abandon an area of superseded road at the junction of Kilkenamurray Road and Catesbridge Road, Banbridge, commencing at the junction of the old road with Kilkenamurray Road and extending for a distance of 233.5 metres in a southerly direction. On coming into operation of the rule, the area of the road in question shall cease being maintained by the Department and the public right of way over it should be extinguished, and the Department is of the opinion that the road is no longer necessary for road traffic. Are there any questions or queries? Okay, thank you. So the Committee for Infrastructure has considered SR 2019-97, the Kilkenamurray Road and Catesbridge Road and Banbridge Abandonment Order Northern Ireland 2019, and subject to the Examiner's Statutory Rules Report, is no objection to the rule. Item 47 is SR 2019-98. You find that at page 339 of your packs. And the purpose of the rule is to abandon 296 square metres of road comprising a turning head between number 10 Berryfields Road and number 3 Berry Drive, Newton Abbey, commencing at the junction of Berryfield Road and Bramble Road and extending for a distance of 22 metres in an easterly direction. The Department is of the opinion that another road is available which provides alternative facilities for road traffic. On the coming into operation of the abandonment, the area of road in question shall cease to be maintainable by the Department and the public right of way over it shall be extinguished. Do members have any questions or queries in relation to this item?
Yeah.
You do? Mr Buchanan.
See access, I presume access was currently through the area that's hatched off. So see the square beyond that, or the rectangle? What's the form of access to that rectangle?
Well, you would suggest it will be by a new development proposal through the hatched area and connecting into the area you've mentioned there.
Okay.
Really a dummy T. I think the intention was to drive the road on through. That didn't happen, and it became a nuisance area for parking and reversing. So the footpath will be reinstated in front, and the access will be into that area. So it will be a new development proposal.
Okay. Thank you.
Okay. Members content? So the Committee for Infrastructure has considered SR 2019-98, the Bramble Road Newton Abbey Abandonment Order, Northern Ireland 2019, and subject to the Examiner's Statutory Rules Report, has no objection to the rule. Item 48, which is SR 2019-100, find that at page 347 of your packs. The purpose of the rule is to abandon 10.7 square metres of footway between number 12 and number 14, Ballybean Park and Donald, commencing at a point 110 metres south-east of its junction with Dungoyne Park, for a distance of 5.1 metres in a south-easterly direction. And this was the site of a former bus shelter. The Department is of the opinion that the area of road is no longer necessary for road traffic, and on the coming into operation of the abandonment, the area of road in question shall cease to be maintainable by the Department and the public right of way over it shall be extinguished. Are members content with this rule, or have you any queries?
Yes.
Content?
Yeah.
Agreed.
The Committee for Infrastructure has considered SR 2019-100, Ballybean Park and Donald Abandonment Order Northern Ireland 2019, and subject to the Examiner's Statutory Rules Report, has no objection to the rule. Item 49, SR 2019-127, find that at page 355 of your packs, and the purpose of the rule is to abandon an area of the former Charleston Road, Portadown, starting at a point 67 metres north-east of its junction with Seagull Road and extending 123 metres in a north-easterly direction. The Department is of the opinion that the area of road is no longer necessary for road traffic. And on the coming into operation of the abandonment, the area of road in question shall again cease to be maintainable by the Department and the public right of way over it shall be extinguished. Are members content with this?
Content.
Okay, thank you. So the Committee for Infrastructure has considered SR 2019-127, U1364 Charleston Road, Portadown Abandonment Order, Northern Ireland 2019, and subject to the Examiner's Statutory Rules Report, has no objection to the rule.
Agreed.
Item 50, which is SR 2019-169, find that at page 363 of your packs. The purpose of this rule is to abandon 26.8 square metres of road comprising 2 areas of footpath at Tyndale Gardens, Belfast, after the completion of such works as the department considers necessary for the provision of alternative facilities for road traffic. On completion of such works as the department considers necessary for the provision of alternative facilities and the coming into operation of the abandonment, the area of road in question shall cease to be maintainable by the department, and again the public right of way over it shall be extinguished. Members, any queries? So the Committee for Infrastructure has considered SR 2019-169, the Tyndale Gardens, Belfast, abandonment order, Northern Ireland 2019, and subject to the Examiner of Statutory Rules report, has no objection to the rule. We've reached item 50, and we've been going since 9:30. So members have agreed that we take a short comfort break. So members are content that we do that at this stage for 10 minutes. Okay, thank you very much. Okay, members.
Yep.
If we just go back then to item 17, which is SR 2017-96, which was the Van Drive Londonderry, which Mr Beggs had raised an issue with, and very kindly officials have ensured that we have had the map sent us very quickly and efficiently, so thank you for that.
Thank you.
Mr Beggs, would you like to follow up on your questions?
Well, it's certainly the map appears to show an adopted footpath in the front. The previous one did not, so I am content with what has been proposed. Has this been delivered on the ground then, or is this just a proposal? This is content.
Okay, members content that we approved. So that the Committee for Infrastructure has considered SR 2017-96, the Van Drive Londonderry Footpaths Abandonment Order, Northern Ireland 2017, and subject to the Examiner of Statutory Rules report, has no objection to the rule. Okay, thank you. Moving to item 51, we're back on track, which is SR 2019-170. The statutory rule can be found at 371 of your pack. The purpose of the rule is to abandon 2 areas of superseded road totalling 3,320 square metres at the former Monaghan Road, Armagh. The Department is of the opinion that another road is available which provides alternative facilities for road traffic. On the coming into operation of the rule, the areas of road in question shall cease to be maintainable by the Department, and the public right of way over it shall be extinguished. Are members content with this rule?
Agreed.
The Committee for Infrastructure has considered SR 2019-170, the Monaghan Road, Armagh Abandonment Order, Northern Ireland 2019, and subject to the Examiner of Statutory Rules report, has no objection to the rule. Item 52, which is SR 2019-225. You find that at page 379 of your packs. The purpose of the rule is to abandon an area of road consisting of former road and embankment at the junction of Crumlin Road and Ballysalem Park in Belfast. On the coming into operation of the rule, the area of road in question shall cease to be maintainable by the Department, and the public right of way over it shall be extinguished, and the area of road in question will be abandoned as the Department is of the opinion that the road is no longer necessary for road traffic. Do members have any queries or questions at this stage? Are you content? Thank you. Yeah. The Committee for Infrastructure has considered SR 2019-225, Ballysalem Park, Belfast Abandonment Order, Northern Ireland 2019, and subject to the Examiner of Statutory Rules report, has no objection to the rule.
Great.
Item 53, SR 2019-226, you can find that at page 387 of in your packs. And the purpose of the rule is to abandon an area of 1,013 square metres of grass-verge meadow in Antrim, commencing at the southeasterly boundary of the Holiday Inn Express and extending for a distance of 225 metres in a southeasterly direction. On the coming into operation of the rule, the area of road in question shall cease to be maintainable by the Department, and the public right of way over it shall be extinguished. The Department is of the opinion that the area of road to be abandoned is no longer necessary for road traffic. Members have any queries, questions? No, you content?
Great.
Thank you. So the Committee for Infrastructure has considered SR 2019-226, the Farrad Meadow Antrim Abandonment Order, Northern Ireland 2019, and subject to the Examiner of Statutory Rules report, has no objection to the rule. Item 54 is SR 2019-228, which is page 395. And the purpose of the rule is to abandon 316.667 square metres of the U7200 Ballygown Road, Drumore, commencing at a point 24 metres southeast of its junction with the C359 Ballygown Road, Drumore, for a distance of 50 metres in a south-easterly direction. On the coming into operation of the abandonment, the area of road in question shall cease to be maintained by the Department, and the public right-of-way over it shall be extinguished. Do members have any queries or questions? Content with this? Thank you. So the Committee for Infrastructure has considered SR 2019-228, the U7200 Ballygown Road, Moor Abandonment Order, Northern Ireland 2019, and subject to the Examiner's Statutory Rules report, is no objection to the rule.
Agreed.
Item 55, which is SR 2019-229. You'll find that at page 403 of your packs. And the purpose of the rule is to abandon 235.6 square metres of road at Tarry Lane in Lurgan, commencing at its junction with North Circular Road and extending for a distance of 31.53 metres in a northerly direction after the completion of such works as the Department considers necessary for the provision of alternative facilities for road traffic. On completion of such works as the Department considers necessary for the provision of alternative facilities and the coming into operation of the abandonment, the area of road in question shall cease to be maintainable by the Department, and the public right-of-way over it shall be extinguished. Members have any questions? Be content? Okay, agreed, thank you. That the Committee for Infrastructure has considered SR 2019-229, the Tarry Lane Lurgan Abandonment Order, Northern Ireland 2019, and subject to the Examiner's Statutory Rules report, has no objection to the rule.
Agreed.
Item 56 is SR 2019-239, and you'll find that at page 411 of your packs. And the purpose of this rule is to abandon an area of 174 square metres of road comprising grass verge at Galway Drive in Belfast, adjacent to number 6 Galway Drive, extending from its junction with Galway Drive for a distance of 37 metres in a southwesterly direction towards Cumberland Drive. On the coming into operation of the rule, the area of road in question shall cease to be maintainable by the Department, and the public right-of-way over it shall be extinguished. The area of grass verge in question will be abandoned, as the Department is of the opinion that it is no longer necessary. Are members content with this rule? Or do you have any queries?
Content.
Content. The Committee for Infrastructure has considered SR 2019-239, the Galway Drive, Belfast Abandonment Order, Northern Ireland 2019, and subject to the Examiner of Statutory Rules report, has no objections to the rule. Okay, we're moving then on to item 57, which is SR 2017-87, and you'll find this in your page 8 of your table items in your. Unfortunately, that wasn't in your main section of your. Oh, okay. I'm hearing that it was an IT glitch. So, but anyway, we now have it on table papers commencing at page 8. So I appreciate members haven't had an opportunity to look at that. Do we have officials in relation to this item? Okay, thank you. Just conscious that members haven't had this in their pack, would you mind just doing a quick overview of this item for them?
Yep. Just by way of a quick background, the European Environmental Impact Assessment Directive first came into force back in 1985, and the directive was aimed at providing a high level of protection for the environment during the preparation of plans for major projects, and to ensure the environment to ensure an assessment of any significant effects on the environment before a project is allowed to proceed. The latest update of the directive came into force on the 15th of May 2014, and then Member States were required to transpose that directive into domestic legislation by the 16th of May or face severe infraction procedures. So there was very much a time constraint to get the resources in place and get the regulations transposed into the various pieces of domestic legislation. The roads EIA regulations NI 2017 were made on the 16th of May 2017, amended Part 5 of the 1993 Roads Order. And Part 5 of the 1993 Roads Order is a bit of the Roads Order that we use when we're processing road schemes, major works road schemes, and considering environmental impacts, effects of those schemes. Consultation on the draft order took place March-April 2017. There was only 9 responses received, mostly supportive. There was 2 suggested small amendments, and they were then incorporated.
What were those amendments?
One related to, in relation to a specific reference in the actual directive that it wasn't being properly transposed. And we were able to go back to say, yes, it was, because we're actually lifting the exact words from the directive. So they were wanting a particular enhancement, but they were satisfied with the response we were getting.
Okay.
And I can provide further.
No, that might be useful, but I suppose the question I want to ask, if it's possible, just in relation to, it refers to competent experts. Can you just ask why competent and not accredited?
Well, that's the reference in the directive. The directive refers that we have to have competent experts available within the department to assess the reports, the environmental impact assessment reports. So previously, what would happen is our divisions would have consultants who would be appointed to prepare environmental statements, what they're termed now as environmental impact assessment reports. But what the updated directive is that the department must have the necessary competencies to assess those reports. So we just don't accept the report coming in for a consultant. There has to be that Chinese wall established. So what we have now done, we have appointed the Council's Shared Environmental Services.
Yes.
So there are independent, competent experts because we don't have the competency within the department. So there are now our competent experts, and they assess the environmental impact assessment reports, the various bits of that report as it comes through to the department, and then makes recommendations to the department. Those reports were completed by competent people, and also they're on the basis that we can make decisions to proceed with schemes.
Okay, and just as a query, just in relation to what's the criteria for competency if you haven't got an accreditation, or is an accreditation part of that criteria?
Well, it's part of the criteria. So those people are competent in their fields and they have all the necessary letters after their name. But that's part of the assessment that SES gives us the insurance that people who have provided or inputted to the environmental impact assessment reports and the different bits of it are competent.
Okay.
And it's not just maybe somebody the consultant has used somebody at a lesser grade just to get something done.
Okay.
It has to be signed off.
Thank you, Mr. Beggs.
Just curious why the department doesn't choose to have at least one person fully competent within the department.
Well, we've always had our consultants who are our competent experts to carry out produce the environmental impact assessment reports. But no, we didn't have anybody of that competency within the department to assess them when they came into us.
Again, my question is, you're almost subcontracting this assessment, so why does the department not have someone with that capability?
It is something that the department is looking at, so we have an environmental governance committee. They're looking at the funding for bringing somebody in, not just to serve roads, but to serve water, drainage, planning.
Okay, so you're looking along the lines of accreditation and for...
And what we have recently done, the department has appointed a dedicated environmental solicitor within the department to help and assist us.
Okay.
It's just in the explanatory memorandum under additional information. It said it breached the 21-day rule. What was the impact of that?
That's right. All the jurisdictions, England, Scotland and Wales, we were all scrambling to make sure that we got these regulations in place. But the actual wording agreed with the other jurisdictions only came in the 28th of April 2017. So we actually only had the final wording in the last couple of weeks running up to the inflection date. When we did make the order and it came into operation on the day, we did acknowledge that we break the 21-day rule. We did write to the examiner of statutory rules to explain the need for doing that, and also to apologise.
So there's no impact?
There's no impact. It's just it's procedural. We always try not to break the 21-day rule. It's there for a reason, but unfortunately in this instance that's what we had to do.
Thank you.
Mr. Boylan?
Yeah, thank you, Chair, and thank you very much for your explanation. The environment's a big topic on everybody's lips at the minute. I have been slightly concerned in terms of, and it goes right across most all the committees as well, say in terms of the consultation process, and I mean, there's been 9 responses. How far and wide have you elevated that process, or is there new ways now of trying to get out to as many people as possible, other than those statutory agencies?
Well, it was a full public consultation, so we did go out to the public, but we went out to all our statutory consultations as well. We can't force people to comment on it, but I suppose what we were doing in this instance, we weren't bringing forward a new scheme that was going to impact. What we're trying to do is tighten up on our arrangements and trying to make the process a lot more neater going forward. So it's a process we were consulting on, not a scheme.
Okay, thank you.
Okay.
Thanks, Chair.
Any other questions? Members generally content?
Yeah.
Thank you. So,
Chair, I was maybe just there was 2 other regulations there. It's number 89 and number 93 in your list, which was again transposing the environmental and the directive into drainage legislation and into planning legislation. It's the same background, it's the same process.
are you content that we can just take those
It's just in case it would help you.
Okay, no, appreciate that, no, thank you very much. So, members are content, the Committee for Infrastructure has considered SR 2017-87, the Roads Environmental Impact Assessment Regulations Northern Ireland 2017, and subject to the Examiner's Statutory Rules report, has no objection to the rule. Okay, thank you. Moving then to item 58, which is SR 2017-31, and the information with relation to this is at page 422 of your packs, and this is with regards to York Street interchange. And the purpose of the rule is for a new grade-separated junction at York Street to provide direct links between Westlink and the M1 and M2. In addition to the construction of over and underpasses, landscaping will be carried out to improve the appearance of the road and lessen the visual impact of the proposed project. This is obviously a very significant project, not only for Belfast, but I suppose really for connectivity across Northern Ireland. And given the level of significance, and obviously there are a number of new members in relation to this, appreciate probably if you could give a little bit of background, because obviously this has been through a public inquiry and so on as well, and subject to lots of negotiations around finances. So if you could maybe just give us a wee bit more information.
Yeah, well, I suppose going forward for all our SRI schemes, the Minister's still been briefed on their full portfolio, and we'll be getting briefing on all the schemes, and then once the Minister then sets out our priorities in the normal run of things, the lead officials, the lead engineers, will be coming to the committee to give a full briefing on the SRI programme and the individual schemes. For this one here, I can give a wee...
I'd appreciate it, yeah, on this aspect.
But maybe just for background, you know, what is a trunk road order? So a trunk road order is sometimes we refer them to as direction orders, or when they relate to motorways, they're designation orders. But they protect the line of the scheme through the planning process. They detail the roads, or the parts of the roads that are going to be part of the trunk road system, the roads that are going to be stopped up as part of the scheme, and also the areas of roads that are going to be abandoned. So it's all done within the one trunk road order. The public inquiry for the orders, the statutory orders and the environmental statement for the scheme was held in November 2015. The inspector subsequently recommended that the environmental statement prepared by the department should be used as a basis to proceeding with the scheme. Then in November 2016, the then Minister made the decision to proceed with the scheme, that the trunk road order should be made of the making of the vesting order part until funding becomes available, and your interchange trunk road order was then made on 24th of January 2017. Following legal action around procurement for the project, that concluded in September 2019.
but unfortunately the award of the contract was then set aside, so departmental officials then taken forward the new contract. I don't know if you need that's as much information as I have, but
Okay, members, have you some questions with regard to that? Mr. Buchanan?
Yeah, I think those drawings are good, but they're not detailed enough. I prefer a larger drawing. Is that the School Literature is a big project. You know, we're not talking about a small piece of land in Lurgan, and no disrespect to Lurgan. But I think if a larger drawing to sort of look at that in more detail.
yeah, well, we can provide that, but I can provide it before the officials come to brief you on the scheme or at that time, but that deal will be set
It
up.
might be useful if we could get that in advance of that, if that's possible.
Yeah.
Or is it holding back your agreement in relation to this, or
I'm not,
would you like to
I'm not clearing that drawing. I wouldn't prefer to stand over that drawing because I can't. It's not that I don't understand it. It's just small.
Okay, would it be possible to have that in advance of tomorrow's meeting, so that we could then
Yes.
have a discussion in relation to this item at that meeting? Would that be okay?
Yep.
Okay, just to give members a little bit more time. Mr. Beggs and Mr. Muir?
You mentioned that there had been legal action which delayed the progress of this scheme. Can you give us a brief summary of the outcome of it, and in particular, do you believe that there are more schemes delayed as a result of legal action here than in other parts of the United Kingdom? We understand we are operating under different purchasing rules and regulations, which lends itself more likely to delays of legal action, sometimes by competitors who lost the tender, etc. So, has anything been done about that?
We live in the world of legal challenges, and it's fortunately that it's just something we have to deal with. There's legal challenges to the purchasing, the procurement. There's also legal challenges to the actual schemes proceeding as well, from the landowners who don't want the schemes. It delays things, but you know, we have a statutory responsibility to properly consider those and put them through the course to their conclusion. That does delay things. Basil Hazard is the airfield scheme. Can maybe give a wee bit more detail of the actual procurement?
Well, the procurement process has stalled really because of the legal challenge to it, which the department had to set aside the procurement as a result of the judicial decision. At the moment, the project is being reconsidered for a new procurement strategy. There's been a report prepared for consideration by the senior management in DFI Roads. They'll decide, subject to possible future funding, and there's possible different streams of funding for the scheme. They'll decide on the likelihood of funding and the best strategy to procure the scheme again. The scheme itself hasn't been altered or changed in any way. It's just the timing of funding, availability for it in the future, and how best to procure it again is what's been considered.
Again, the question I had asked around our purchasing mechanism, I've been led to believe that there is minimal risk to those who pursue a legal challenge and delaying a sizeable scheme like this, whereas in other parts of the United Kingdom, if you do so on good, firm grounds, that's fine, but if you do that on perhaps weak grounds and unnecessarily delay a scheme, you can obviously upset public procurement, but not perhaps bear a significant burden of the delays and legal costs involved. Would that be the case?
I'm not aware of the magnitude of the costs for legal challenges. Obviously, if the department loses their case, they pick up the bill for the legal costs for the other side. We haven't been told what that is yet, but it could certainly be substantial. The costs to any tenderer to tender in the first place are significant. They have to put quite a bit of resources into that, and so the cost of challenging probably isn't so significant in comparison. They will still have their legal bill to pay. I can't put a quantity on what it would be. Now, it would be fairly significant, I would have thought, though.
If I've picked you up, just final point of me, if I picked you up right, you're not intending to change anything, just re-tender to do with timing, is that correct?
It's to do with timing and funding strategy. I'm not aware that we can impose penalties on tenderers to challenge in instances where they challenge.
Again, my understanding is there's different procurements in other parts of the United Kingdom which can inhibit that. Particularly, I'm hearing that you're going to apply for the same scheme again. You don't feel there's any need to change?
Well, the procurement strategy may change. A different type of means of procuring at this time. Instead of maybe a two-stage contract, it could be a one-stage contract. Stuff like that, really.
But would you accept there's considerable costs also to the public first and the department in having to go through multiple tendering procedures?
Well, there is, certainly, yes.
No doubt we'll be revisiting this one again. So.
Yeah.
Chair, I was just going to add on costs. If there's if the legal challenges are on environmental grounds, and they're entitled to cost protection through the courts, and they automatically get it, and it's usually in the region of 5,000 maximum they would be liable for if they lost their case, and 30,000 against us if we lose the case. But that's the way the courts, that's the way the system is set up to allow a small person to challenge a big conglomerate on an environmental matter.
What if a large multinational company challenged on a environmental grounds because they lost the contract?
Well, it's still a matter for the court to decide.
Well, the environmental grounds, that would have passed. The opportunity to challenge on environmental grounds would have passed by that stage. Yeah.
Okay, thank you, Mr. Muir.
Yeah, thank you very much, Chair. Just echoing the words of Mr. Buchanan, it would be very good to get a bit more detail just in relation to this. I know some concerns have been expressed around how it's going to facilitate more sustainable transport, especially on York Road in terms of cycling and stuff like that, so we'll be very keen to get more information in relation.
Is that for tomorrow, Chair? Or is that...
Well, I think in this, tomorrow really will be about the map, and then there'll be further discussion as it moves forward.
Yeah, I think the map hopefully should sort of give more detail really in relation to that.
And maybe, Chair, just to say to the members, if they're ever in Clarence Court, that there is a 3D model of York Street interchange, which actually, when you look at it, you'll see it in all its glory.
Okay, thank you. Okay. So, members content, then we defer this item for more information till tomorrow.
Content.
Yeah, thank you. Item 59, which is SR 2017-194. You find that at page 445 of your packs. The purpose of this rule is to stop up Dalton Street, Belfast, at its junction with Littlepath Street. The term stopping up means that once such an order is made, the highway land will cease to be a highway, road or footpath, and stopping up orders are often made because the public highway is no longer necessary or to allow development to take place. Are members content with this rule? Any queries? Content?
Yeah. Content, yeah.
The Committee for Infrastructure has considered SR 2017-194, the Dalton Street Belfast Stopping Up Order, Northern Ireland 2017, and subject to the Examiner's Statutory Rules report, has no objection to the rule.
Agreed.
Thank you. The next item is item 60, and it's SR 2017-226. And information again is, and this is at page 454. We'll ask an official to come to the table, maybe just if you're already here, to just explain the revocation of the rule. Obviously, this was due to a court ruling. Just give us some more information in relation to that.
Sorry, is this 226?
Yes.
So following the 2016 public inquiries into the environmental statement and draft statutory orders for the A5 Western Transport Scheme, PAC issued its report in May 2017, and then the decision to proceed with the scheme was announced by the Department in November 2017. In December 2017, the Department received a legal challenge to that decision to proceed with the first phase of the scheme. That's from new buildings down to just north of Strabane. The decision to proceed with the scheme and the statutory orders were subsequently quashed by the court on the 16th of November 2018. So the Department is now carrying out the necessary work to enable a fresh decision. for the scheme to be considered, and a further public inquiry is scheduled to open on the 18th of February this year.
Okay, so just in relation to this, then what really then are the next steps for, what are the next steps for yourselves and then for us?
Well, the question and the decision by the court took us back to that stage where the department is preparing all the necessary papers and backgrounds to enable the decision to be taken on the scheme, to taken to the new minister. But part of that there was, because of the time lapse between 2016 public inquiry and now, there had to be further updates on the environmental side and the appropriate assessments carried out. So we did consult with the public. We got 60, 70 responses in, and we need to have a public inquiry which PIC is going to chair for us to consider those representations. We have to wait to the outcome. We can't preempt the outcome of the public inquiry, so we have to wait till the public inquiries complete a PIC submission of the report and allow officials then to consider that and decide.
Okay, thank you. Mr. Beggs.
In your memorandum, you've indicated that all but one of the PAC recommendations have been adopted by the department. Can you advise which one has not?
You might have it in her report anyway. Get them to write it. Awesome. Still, I'm not a still.
It's on the second page of the memorandum. Or provide us written information subsequently.
Sorry, I apologise, I haven't got that because I'm not the engineer for the scheme, so I'll bring.
Another issue I see in the commentary, it said that there were specific issues about value and cost of the preliminary design, particularly in the Upnacloy to Ballygolly stretch. And I'm certainly aware that a few years earlier there was a multi-million-pound roundabout scheme at the end of the extension to the M1, and the proposal was to bypass that multi-million-pound roundabout and build another new multi-million-pound roundabout. So I'm not surprised that there are cost and value issues. But can I ask as well, when this scheme was first announced, it was accompanied with an offer of 400 million, either euros or pounds, can't remember, from the Republic of Ireland to help pay for the scheme. Can you advise, given that we are in now a time of austerity, we are struggling with lots of schemes, lots of road improvements, potholes, can you advise what contribution has actually been materialised so that this scheme, which does improve access to parts of the Republic of Ireland as well as ourselves, what funding has actually been received from the Republic of Ireland towards this scheme?
Chair, and I appreciate the questions Mr. Beggs is asking, but they're more for the engineer for the scheme. I'm here to talk about the legislation, the direction order which was quashed. Those questions could be answered from the officials.
Okay, well, if you consent, again, this is a substantial project which will require more than just a few moments in the midst of this, and I think it's probably would be wise for us to set aside some time in a further committee just to get information with regards to that. And obviously the Minister will be here in a couple of weeks' time as well, and it might be something again that we may want to talk to her about. Okay, but just with regard to where we are today, obviously my understanding is that this is still on the statute books, so and you may need to write to us just to give us an update with regards to the High Court outcome.
Well, my understanding is that the High Court ruling means the statutory order doesn't exist.
It doesn't exist. It's just that because it's
still there.
It's with us. So
some we've never come across before. So
okay, so perhaps in order to rectify that, and then obviously we can pass that then on to the examiner as well, just to.
So, just for clarification, you're saying that this is going to be nullified, cancelled? This draft, this first.
Yes, we can't move forward with this given that the High Court ruling.
So it doesn't, as far as the court is concerned, it doesn't exist.
Okay.
Okay, but we do need to spend time on this issue at a later date. Okay, content?
Yep.
Item 61, which is SR 2018-30. Information's at page 514 in your packs. The purpose of the rule is to stop up lengths of the central reservation of the dual carriageway of the A1 Newry Road and the A1 Banbridge bypass between Springwell, Lowan and Castlewellan Road Bridge and Banbridge. Do members have any questions in relation to this? Obviously, again, this is an ongoing safety issue along the A1. Would officials wish to comment?
Is a similar.
No, we have to take them really in order, if that's okay. If we just look at 2018-30.
Yeah.
Okay. I was just making the comment that obviously this is part of an ongoing piece of work in order to upgrade safety along the A1.
Yeah. It's a precursor to the grade separated junctions and
Yes.
stuff. There was a number of median crossings identified that were either not being used or there was alternatives. We discussed it with the landowners who were directly impacted on it and got their agreement to close them off, basically. So yes, it was purely a safety issue.
Okay, and sort of, as you're moving forward with the scheme, you know, where there are issues, will there be, and I know that this has been identified when we were doing Frosses and so on and other sort of major road schemes, underpasses for local farmers and alternative routes, that's all been
considered as part of the design,
discussed?
yeah.
Okay. Do members have any?
Just for clarity, Chair, this is all part of the road safety schemes?
Yeah, the A1 grade separated junctions, yeah.
Thank you.
Okay, anyone else, any comments on this one? Okay, thank you. So the Committee for Infrastructure has considered SR 2018-30, the A1 dual carriageway between Springwell, Lonan and Castlewellan Road Bridge, Banbridge, stopping up order Northern Ireland 2018, subject to the Examiner's Statutory Rules report as an objection to the road. Okay. Item 62, which is SR 2018-178. You find that at page 527 in your packs. The purpose of this rule is to stop up 2 lengths of Pond Park Road and a length of Beanstown Road. Lisburn at junction of the Pond Park Road, Beanstown Road as part of the new road layout. Are members content with the rule or any issues?
Content.
Content. Committee for Infrastructure has considered SR 2018-178, the Pond Park Road and Beanstown Road, Lisburn stopping up order Northern Ireland 2018 and subject to the Examiner's Statutory Rules report as no objection to the rule. Moving then to item 67, which is SR 2019-6. You find that at page 535 in your packs. And the purpose of these regulations are to amend a number of statutory rules to clarify that statutory responsibility for the related functions has transferred to the Department for Infrastructure from the Department of Environment. Are members content with this rule? Have any queries regarding it? Okay, it's very straightforward. Okay. The Committee for Infrastructure has considered SR 2019-6, the Road, Traffic and Vehicles and Waterways Amendment Regulations, Northern Ireland 2019, and subject to the Examiner's Statutory Rules report has no objection to the rule. Item 64, SR 2019, and you find that at page 546. And the purpose of the rule is to extend the lengths of the city-bound hard shoulders of the M1 and M2 motorways, including the city-bound off-slip at Fort William roundabout, which can be used as bus lanes, and amends the hours they're available for use by buses and coaches from 7 a.m. to 7 p.m. on Monday to Friday inclusive. The rule also adds a length of bus lane on a purpose-built length of carriageway at the Duncrew Street off-slip of the M2 motorway, which terminates at a new bus gate, which is a set of traffic lights established for the sole use of buses or other vehicles permitted to use the bus lane leading up to the bus gate. Is at its junction with Duncrew Street. This bus lane will operate 24/7 in tandem with the bus gate. The provision of the new and extended bus lanes is intended to improve bus journey times and service reliability on the M1 and M2 corridors, and therefore to encourage modal shift from car to bus use and help reduce congestion and encourage more use of the department's park and ride facilities. Any person who acts in contravention of the regulations shall be guilty of an offence and shall be liable on summary conviction to a fine not exceeding level 4 on the scale, and that's up to £2,500. Traffic signs indicating the effect of the regulations will be in place in due course on those roads. PSNI has been informed and has agreed to the regulations. No quality issues have been identified by the department, and there are no financial implications. So clearly there were no objections to this. Just in relation to the use of the hard shoulder, obviously hard shoulders used traditionally if there's a breakdown. What happens if there is a breakdown in that section of the road? And obviously it's, I suppose you tend to want to go to the hard shoulder.
Yes, the hard shoulder is always available as a hard shoulder in the event of a breakdown.
Okay.
At times when the bus lane is in operation, there are signs to indicate that it is in operation. These signs are variable message signs, so they can be rotated. If a breakdown occurs, they can be rotated to close the bus lane to buses.
Okay.
Buses then revert to using the normal lanes of the carriageway.
Okay, so it'll still be used for a hard shoulder in the event of a breakdown?
Yes, yes.
Okay. Okay. Any, Mr. Buchanan?
Just a quick question. Is there any speed restriction on a bus on a hard shoulder?
There is, well, it is an advisory speed limit. We can't impose a different speed limit on the hard shoulder to the main carriageway. So we have on the signs an advisory speed limit of 40 miles an hour.
For the bus?
For the bus, yes. For the hard shoulder only.
So it's advisory only?
It's advisory only.
Okay.
Hey, Mr. Boylan?
Thanks, Chair, and thanks for the explanation. Just in relation to two things, and I do appreciate that. I hope that they do move to use more public transport, the principle behind that, but in terms of objections or any serious comments in relation to it?
No, we consulted with the councils and with the police, really, main bodies involved. No objections at all. The police are important because if there are issues, they will enforce them. Such as that they can't enforce an advisory speed limit, but they can nevertheless warn the drivers appropriately.
Thanks, Chair.
Okay, anyone else any queries? No? Thank you. So the Committee for Infrastructure has considered SR 2019-19, the Motorways Traffic Amendment Regulations Northern Ireland 2019, and subject to the Examiner of Statutory Rules report, has no objection to the rule. Item 65, SR 2019-167. You'll find that at page 556 of your pack. And the purpose of this rule is to stop up Millmount Road, Dundonald to vehicular traffic 2 lines northwest of its junction with Millmount Roundabout after the completion of such works as the department considers necessary for road traffic. Members, any comments, queries, intent? Committee for Infrastructure has considered SR 2019-167, Millmount Road, Dundonald stopping up order, Northern Ireland 2019, and subject to the Examiner of Statutory Rules report, has no objection to the rule. Moving then to item 66, which is SR 2017-89, and you'll find that at page 565 of your packs. And the purpose of the rule is to amend the Motorcycles Protective Headgear Regulations Northern Ireland 1999 to require riders of motor quadricycles to wear protective headgear when driving or riding on a public road. Just to note that this rule is already in operation. Do members have any queries in relation to this, or is there an official that to speak to this? Yeah. Thank you. Mr. Buchanan?
Yeah. Alex, just a question on quad bikes relating to farmers, for example. Yeah. Is there a rule currently, if the farmer's on his or her own land, that they need to wear any protection?
No, there's not.
And is any, let's say a farmer owned a property on both sides of a road. So technically they're crossing a public road. So crossing a public road is on a public road.
Once they go onto a public road, yes, the requirement would be that they would have to wear a helmet.
And there's no, only some rules, a farmer can have so far to go from his or her own property. But if they're on the public road, they're on the public road.
That's correct, yeah.
So there's no regulation to wear it if you're on the farm.
No.
But if you go on the public road.
No.
Okay, and are there any fines attached to this, or?
Yes, the obviously penalties. It would be a case for, this would be enforced by PSNI primarily, so it would depend on severity of the offence. You know, if someone's riding a quad without a helmet and has a passenger who's also, because obviously there are quads that will take 2 people rather than just one. I don't know, Chair, if you want a bit of background in this.
It might be useful, actually.
I could certainly offer that to you. I mean, this was brought to the department's attention around 2011-2012 by the public, by and large. The issue was that, and you may recall some of them, there was a number of fatalities where individuals, including young children, died as a result of falling from a quad on a public road. So the department actually engaged with the then committee, the then DOE committee, to take their views and to suggest that perhaps this is something that we needed to look at. The committee agreed and we carried out a consultation. Now, the result of that consultation resulted in a slightly more in-depth look at the number of deaths and casualties as a result of accidents going back a number of years. And we find that of 4 deaths that spanned a 5-year period, 3 were as a result of the rider of the vehicle or the passenger, as the case may be, not wearing a helmet. And that was borne out by the subsequent autopsies and the report on that. What the autopsy couldn't say is that whether the wearing of a helmet would or would have not protected the individual, but the general consensus was that if you're wearing a helmet, you're obviously better protected than not. So hitherto the legislation that you quoted earlier only covered the riders of 2-wheel motorcycles, and the department then subsequently sought and was given permission to make this amendment that would cover quads, and it has been in operation since then. It doesn't, as you rightly say, extend to farmland, although it may be a benefit of you to know that there is training provided by the Department of Agriculture through its colleges for farmers who use quads. It's not mandatory that they wear a helmet, but they are given the advice that it may be beneficial to do so.
Okay, thank you. Mr. McCartney.
It's just this differentiation between public and private land. Do you have to wear a safety belt in private land?
Private land, our legislation doesn't extend to private land at all in relation to, particularly if you're involved in agriculture or horticulture or whatever, because these vehicles are used in many forms. So our primary focus was that if you're using on the public road, do so. Not only do you have to wear a helmet, but the vehicles have to meet construction and use requirements. So that refers to safety belts, lighting, indicators, braking, all those issues that would be covered by a normal vehicle that would use the public road. So they must comply with all of those once on the public road.
That sounds hard. Yeah, but I mean, just it's making that differentiation. Where some people might ask if it's unsafe to wear it on a public road, then you're sending a message nearly it's no subordinate, but it's okay in private land.
But currently, I mean, it's a fair enough point, and it's a debate that maybe needs to be had at some stage. The department's legislation does not extend to private land, so we have no remit in relation to private land.
But that's why I asked. If you were driving a car on private land, you would have to wear a safety belt. So it extends in that purpose, does it?
No, sorry. No. I mean, on private land, you're not.
You don't have to wear a safety belt.
No, we don't enforce that.
Right.
Okay. Thank you. Mr. Boylan?
Yeah, thanks, Chair. And how's it going, Alex?
Thanks.
It's been a while.
Thank you.
You're back again. No, I do welcome this, I think, but just in some of the comments, I mean, because some of the farms, some of the travel distances, it's just more than across the road immediately. And I would like to, you know, I was going to ask the question like Raymond has asked already, but I would like those discussions now to take place to see what else we can do, even if it's working with UFU or even the department, in terms of what we can bring forward, some kind of a policy agreement or something. Because, I mean, to me, we know there a number of years ago there was a lot of incidents, and I mean, it's a no-brainer in terms of wearing a helmet across it. So I would welcome a further step if we can follow on from this.
And certainly that would be cross-departmental, obviously, and that would have to extend to that area. You know, certainly if it's something you feel the Minister should do, I'm sure she'd be happy to do so.
We can either write to the Minister or we can speak to her whenever she's up.
Yeah, Chair, I'd like to back in the committee. I think cross department we should ask that question, start that discussion. If the members were agreed to write even.
Oh, okay. And to do that, Mr. Hilditch.
Okay, Chair. When has this been implemented from?
It came into operation. Sorry, people might refer to my notes. May 2017.
17. So, is there any figures at how successful it has been, or could you tell us anything about this?
No, we don't actually collate figures. As I say, we had to go to PSNI to obtain the figures when we carried out the consultation. Certainly, it's simple, relatively simple to ask them to look at that, or actually.
Just wondering how successful it has been to date, you know.
Well, I mean, I do know there's been some fatalities since. In fact, there was a farmer who was, I think, moving from one field to another, tragically killed. So, you know, it's obviously it's there, and we hope people realise that they can't do this on the public road. They put a helmet on when they are entering a public road, but we can't enforce it when they're on their own land.
Okay. Thank you very much. So, members are content that the Committee for Infrastructure has considered SR 2017-89, Motorcycles Protective Headgear Amendment Regulations Northern Ireland 2017, and subject to the Examiner Statutory Rules Report, has no objection to the rule.
Agreed.
Moving then to item 67, which is SR 2017-117, and you'll find that at page 578 of your pack. And the purpose of these regulations are to transpose the EU directive on the recognition of professional qualifications, Directive 2005/36/EC, as amended by Directive 2013/55/EU, as it applies to driving and motorcycle instructors. They complement the European Union Recognition of Professional Qualifications Regulations 2015. These regulations provide for the recognition in Northern Ireland of the professional qualifications of motor car driving instructors and motorcycle riding instructors obtained in the European Economic Area or Switzerland. They do so by making complementary amendments to the relevant road traffic legislation to ensure that the rights granted to qualified European driving and motorcycle instructors by the 2015 regulations are compatible with that legislation. Do members have any queries or questions? Are we content to approve? The Committee for Infrastructure has considered SR 2017-117, the Driving and Motorcycle Instructors Recognition of European Professional Qualifications Regulations Northern Ireland 2017, and subject to the Examiner's Statutory Rules Report, has no objection to the rule. Moving then to item 68, which is SR 2017-127. You'll find that at page 596 of your pack, and the purpose of the regulations is to amend the bus and coach passengers' rights and obligations designation and enforcement regulations Northern Ireland 2014 to extend exemptions under Article 2.4 of Regulation EU number 181/2011 of the European Parliament and of the Council of the 16th of February 2011 concerning rights of passengers in bus and coach transport and amending regulations EC number 2006/2004. Do members have any questions or queries, or are you content with this item? Content. Okay, so the Committee for Infrastructure has considered SR 2017-127, the Bus and Coach Passenger Rights and Obligations Designation and Enforcement Amendment Regulations, Northern Ireland 2017, and subject to the Examiner's Statutory Rules Report, there's no objection to the rule. So that's our first file completed. We move on to the second file. Just bear with us a second. Thank you. Okay, so we move then to item 69, which is SR 2017-139, and you'll find information there at page 605. And the purpose of the regulations update the reference in the Public Services Vehicles Conditions of Fitness, Equipment and Use Regulations in Northern Ireland 1995, and it's SR 1995 number 447 to the British Standard, to which portable fire extinguishers fitted in a public service vehicles PSV must comply, that's i.e. BSEN 37 2004 plus A1 2007. Accordingly, PSVs must be fitted with a portable fire extinguisher which complies with BSEN 3/7 2004 plus A1 2007, and which has a minimum test fire rating of 8A or 34B, contains water or foam, and has a minimum capacity of 2 litres. These changes pertain also to the next two SRs, and that's 2017-140 and 2017-141. Do members have any queries or questions? Mr. Beggs, have we got someone to answer for us? Alex? Mr. Beggs.
Okay, thank you. I can understand a wish to have fire extinguishers in vehicles. There's a potential risk to passengers, probably a lesser risk in smaller vehicles than larger vehicles, because you're straight out the door and you're out. So you wouldn't stop to pick up a fire extinguisher and spray the inside of the cab, but you just get out. So I'm just curious the route that has been taken by the department in these regulations, particularly as the associated additional cost, which will fall on thousands of taxi drivers. You're indicating you consider the money to be negligible. It's £25 at least a taxi, and then an ongoing running cost, another £10 a year. These are hard-working people we're imposing burdens on. And I'm seeking an explanation why we are imposing proposals which go beyond the EU requirements. You've indicated that it's going beyond the EU requirements, with a total outlay for business of £1.8 million over the next 10 years, and a net cost per business per year of £146,000 for the first proposal anyway. So could you provide me some answers?
Well, first of all, obviously, the key issue here is about the safety of the passengers. And I do take your point about smaller vehicles, i.e. a taxi. There are fewer people in it, as opposed to a bus. But we view this as a safety issue regardless, because these are people who are obviously paying to be transported from one place to another. So the onus is on the driver of the vehicle and the owner to ensure that they are safe. We are, as you rightly say, going beyond the directive, and I'll give you a bit of background in that. As it stands at the moment, or as it stood, a 1 litre fire extinguisher was deemed to be adequate for public service vehicles, buses, taxis alike. However, when colleagues in DVA, and this is primarily how it first came to our attention, were testing these vehicles, they found that a considerable
considerably high percentage, over 90%, either failed to have a fire extinguisher fitted, or that the fire extinguisher was not effective, wasn't capable of being used, was out of date. That was mainly, I have to say, in taxis as opposed to public service vehicles, because bear in mind this applies to TransLink as well, and obviously they fully complied with it. The issue about why we went beyond relates to a new standard that was brought in the UK in relation to fire extinguishers. It's called the EN3 standard. And the approval markings that are currently required to note that. We were conscious, as you say, that we were going slightly beyond what the directive said, so we sought legal advice from the Department Solicitor's Office, and they came back and advised that the Department should, on their advice, take steps to update the references to the EN3 standard, and therefore introduce it as the new standard that should be used. And we carried out a public consultation on this. We got 5 responses to the consultation. 2 were opposed to it, and 3 said that they supported it fully. One of those being the Northern Ireland Fire and Rescue Service, who indicated that they felt as an initial standard and requirement that the new 2-litre fire extinguisher should be fitted, and that's why we went forward. I do acknowledge the point you're making about the cost. It is approximately £25 to install one of these extinguishers, but they have a life usually of about 5 years. So when you look at it in the round, the yearly cost, I would suggest it is minimal in terms of the potential benefits that would derive should the driver of either a taxi or a bus be required to use a fire extinguisher.
You've indicated they have an actual maximum life of about 5 years, but you're proposing to ban one type of fire extinguishers on environmental grounds. I think it's using halon gas. Why not let that simply, instead of discarding it and requiring additional natural resources to be manufactured into new fire extinguishers, why not let that brand of fire extinguisher extend its 5 years and then be discarded or recycled?
Yeah, and you're right, for environmental reasons, but also the potential for those particular type of extinguishers to not be effective was the advice that we were given by health and safety colleagues. I accept, as I say, it is a cost, but we think a minimal cost that we're imposing for potentially a much greater payback benefit.
Okay. A final point that gives me a degree of concern. You yourselves indicate that these 2-litre extinguishers are much more bulky than normal, than the old style extinguishers, and will be difficult to find a space for them in many modern cars. So how practical is this proposal for taxis in particular?
Well, and you're right, the issue was currently a lot of taxi drivers have the fire extinguisher fitted to the footwell of the passenger side of the vehicle. And they rightly said to us, look, you're asking us to put a much bigger fire extinguisher in our vehicle. So with consultation with the DVA colleagues, we agreed that the fire extinguisher can be fitted in the boot of the vehicle. Now that does require the driver to get out and access the boot, but that was, if you like, the alternative to fitting it in the footwell. Of course, it all depends on the type of vehicle you drive. A lot of taxi drivers now drive 7 or 8-seater vehicles, which are much larger and have a greater ability to facilitate this within the cab. But yes, it wasn't just as simple as saying put that into your vehicle inside. Particularly for taxi drivers, it wasn't an issue for buses. In fact, TransLink made some retrofitting to their buses so they could accommodate the larger fire extinguisher.
And this is already happening now, isn't it?
Yeah, it has happened. There was a deadline for which these things had to be installed, and in fact, with colleagues in DVA, we implemented a process where we would blitz, for want of a better term, once these were fitted. Either taxi drivers or bus operators could bring their vehicles on a number of prescribed days to a test centre, have them approved, so that, because we are conscious, these are men and women who are working for a living, we did not want to put someone off the road for an indefinite period. So we attempted through that process, and we did manage. So it's a rolling chair process now. When these vehicles come to the test centre for testing, the fire extinguisher is examined by the vehicle examiner, and if it meets the current requirements, it's approved. If it's not, please.
The final area which gives me, I'm curious about, is that there's no equivalent legislation in Great Britain.
No.
They have operated using the trading standards, so why did you decide to bring forward legislation to deal with rather than through trading standards?
Well, as I say, we looked at the alternatives, and that's why we sought advice from DSO, and they were, based on their consideration of it, they were of the view that we should go down this route. Now, I wouldn't personally be brave enough to reject or ignore the advice from the Department Solicitors' offices, and at the time the department took the view that we should go down that route.
Did you have any engagement with the taxi drivers? Because obscure legislation is not their big thing. They're out there trying to get a living. So did you have direct engagement with them in order to take their concerns about additional costs on board?
Well, first of all, as I say, we did do a public consultation, so they were free to respond to that if they wished. And yes, a number of them contacted. At that time, I was actually responsible for taxi legislation as well. Contacted me personally to ask why we're doing that, or proposing to do this, and I explained into them, as did other colleagues in the taxi unit. So we didn't. If you mean, do we go out and organise events to specifically talk to taxi drivers? No, we didn't do that.
Putting a bigger one in the boot's a great idea, as long as there's no luggage in the boot.
Yeah. Well, to date, I haven't. Certainly, no one's contacted me from the taxi industry to say that they have an issue with it.
Okay. Mr. Boylan?
Yeah, thank you, Chair. Just following on from what you asked yourself, this is already in vogue. How long has it been in?
It's been in, sorry, dates are not my strong suit. Certainly a couple of years ago, 2017.
And Alex, in terms of the feedback from the industry itself, I mean, have you done any initial soundings on what the industry is saying in relation to?
Well, from a policy point of view, no, we haven't. But what I would have suspected and would imagine would have happened if there was an issue when the vehicles were coming through the test centre, our colleagues in DVA would have probably flagged that up to us to say there is a problem here. Certainly, we haven't had any conversations with them about that to suggest that there are a large number of taxis coming either with a defective fire extinguisher or no fire extinguisher fitted. So, not always no news is good news, but on this occasion,
No, I just asked in the context, and you well know it as well as some members, maybe in the committee, the taxis regulations and act has been around a long time, you know, and they're very proactive in responding to a lot of things. So I asked it in that context.
Sure, fair enough. What I can say is certainly no, I'm not aware of any either individual taxi drivers or taxi groups approaching us since the introduction of the legislation to say they still have issues with it.
Okay. Content?
Thanks.
I would just like to note that I think this is an issue of gold plating, and I'm quite sure all taxi drivers are installing these, or else they're off the road, so they're bound to be installing them. I think this is an issue we've gone further than others.
Okay. So members content then we move forward with the rule?
Intent.
So the Committee for Infrastructure has considered SR 2017-139, the Public Service Vehicles Conditions of Fitness, Equipment and Use Amendment Regulations Northern Ireland 2017, and subject to the Examiner's Statutory Rules Report, has no objection to the rule. And obviously the next two are also linked to the same issue. So the Committee has also considered SR 2017-140, the Motor Vehicles Construction and Use Amendment Regulations Northern Ireland 2017, and subject to the Examiner's Statutory Rules Report, has no objection to the rule. And the third linked SR is SR 2017-141. The Committee for Infrastructure has considered SR 2017-141, Taxi Licensing Amendment Regulations Northern Ireland 2017, and subject to the Examiner's Statutory Rules Report, has no objection to the rule.
I simply wish that my concern about gold plating would be noted on both these SRs.
Okay, that's noted. Okay, thank you very much. Members, I think only because we've come to a natural break with that set of regulations, if you're content that we will suspend our sitting today and reconvene for the remainder of our packs we considered tomorrow's meeting, which will take place at 10 a.m. in the Senate chamber. If you're content, we'll adjourn.
Thank you.
Suspend.